discretion on what the sentence shall be imposed. Rather, life imprisonment is mandatory. The court notes, however, that the defendant has an adult criminal record dating back to 1989. This history, coupled with the horrific nature of these offenses against his own child sister, requires that this defendant be removed from society for the protection of society. This sentence provides for both punishment and for protection of the community. Mr. Dinkins, it's unconscionable that you would take such actions to murder a 10-year-old child who was entrusted to your care. It is very clear to this court that you have no conscience or remorse for your actions. You blatantly lied about trying to find Breasia. You took no legitimate actions to find her. You knew exactly where she was. Due to your extensive criminal history and the fact that you removed Breasia from the place that you were authorized to care for her, and then take Breasia to a dark, deserted area in the country and shoot her in such a horrific manner, supports the finding that the sentences to be imposed on both counts 1 and 2 shall be served consecutively. Mr. Dinkins, pursuant to this court's finding you guilty on September 15th of 2023 of murder in the first degree in violation of Iowa Code Sections 707.1, paren 1, paren A, and as provided by Sections 902.1, it is the judgment and sentence of this court that you be committed to the custody of the Iowa Department of Corrections for the rest of your natural life without the possibility of parole. Pursuant to this court's finding you guilty on September 15th, 2023 of kidnapping in the first degree in violation of Iowa Code Section 710.2 and as provided by Iowa Code Section 902.1, it is the judgment and sentence of this court that you be committed to the custody of the Iowa Department of Corrections for the rest of your natural life without the possibility of parole. DNA sampling will be required. Each of these counts will be served consecutive to one another for the reasons stated earlier. The Iowa Medical and Classification Center is designated as a reception center to which you shall be delivered by the sheriff. Pursuant to Iowa Code Section 910.3B1 in paren 1, you are ordered to pay to the heirs of Breasia Terrell, and as noted by the county attorney, to Aisha Langford, $150,000. Mr. Freeze, do you wish to address Category B expenses at this time?
Your Honor, I believe that given Mr. Dinkins' status presently and going forward, he'll certainly be indigent and qualify for a waiver of Category B expenses.
Ms. Cunningham, do you wish to address the court on this matter?
No, Your Honor, and the state would not resist the court entering that finding.
Based on that, the court will find that Mr. Dinkins is indigent and does not have the reasonable ability to pay Category B expenses. Now that you have been sentenced, it is my duty to advise you of your right to appeal. Under Iowa law, you have the right to appeal your conviction and sentence to the Iowa Supreme Court. In order to do so, you must file a written notice of appeal with the clerk of this court within 30 days from today's date. Failure to file such notice of appeal in that fashion will be deemed a waiver of your right to appeal. In other words, you will lose it. If you think you want to appeal but don't think you can afford an attorney or transcript of these proceedings for that purpose, you have a right to make application with this court for court-appointed counsel and a transcript of these proceedings, all at the expense of the state of Iowa. Just be aware all of this must be done within the 30-day time limit that I have just outlined. I'm sure if you have any questions concerning this, Mr. Freeze or Mr. Waters would be happy to address this with you. I'll acknowledge receipt of any pre-sentence investigation reports that have been printed for the purpose of today's sentencing. No appeal bond will be issued in this case. minimis will issue immediately. Anything further in this matter?
Your Honor, I do want to make a record relative to some comments of Mr. Dinkins. Mr. Dinkins spoke to the issue of the state having provided all of these exhibits during the trial that he had not received. The state did comply with all discovery requests that were made. I would note that there were a significant amount of photographs, there were a significant amount of body-worn camera footage that was generated by virtue of officers and their involvement in the investigation, as well as recorded interviews. There is a record that would reflect what was provided by discovery, but I want to speak to the practice of this particular prosecutor when I am in trial. My practice has always been one to make copies of any exhibits that I'm going to introduce during the trial and provide that to counsel. So while they may have received that during the course of discovery, I find that it's very beneficial for defense counsel just to have a copy that I'm presenting to the witness right there on the table before them so that they can follow along as I'm introducing those exhibits. I want to make it clear that when Mr. Dinkins suggests that these were exhibits that were just came out of the blue and were presented for the first time, that was not the case. It's simply the state's way of being very considerate of my colleagues on the opposite side of the table and making their jobs easier and making the process flow much, I think, more efficiently by providing those copies. So I think it's important to make that record. Additionally, Mr. Dinkins had indicated that there was a lack of notice of various witnesses. Certainly the court understands and defense counsel understands that with respect to any type of criminal prosecution, the state's required to file minutes of testimony, and then if there are, supplemental additional minutes of testimony that need to be filed, that is done. There were several sets of minutes of testimony that were filed. Every witness that was called to the stand to testify were individuals who were listed in those minutes of testimony, and every report that documented their statements to law enforcement or any investigative steps taken by law enforcement was a part of those investigative reports. And in fact, the state would further speak to the issue of expert testimony, particularly that of the FBI's testimony. My predecessor, who had been on the case before I took office, had filed additional minutes of testimony indicating there had been a USB drive provided that set forth all of their investigative reports.